Good afternoon and welcome to Changes in Labor Laws 2023, What You Don't Know Can Hurt You. I'm Angela DLHA Ashley, founder and senior managing attorney at DLHA Law Group. We are a full-service business and employment law firm founded over 22 years ago with a focus on giving businesses the attention they need for almost any legal issue that arises. We have a strong team of attorneys with experience in many practice areas to provide our clients with legal guidance so that our clients can focus on their businesses. Today, you'll hear from me and also two of our lead attorneys, who I will introduce momentarily. The webinar should run about 45 minutes. We'll have time for questions and answers at the end. And this is an overview of the new laws for 2023. As a reminder, we are not providing legal advice today. To provide you with legal advice, we would need to meet with you, discuss your issues, understand your facts, and then we would need to apply the law to those facts. So please don't rely on the information in this webinar as you would legal advice. However, as a courtesy to our webinar attendees, we are offering a complimentary 20-minute consultation for employment-related questions, but please contact us in January to set up that appointment. At the end of the webinar, we will have a question and answer session. As I said, you can submit questions by using the Q&A box at the bottom of the Zoom screen. Please don't use the chat box, use the Q&A box, but you can submit your questions at any time during the webinar. If we do not get to your question, or if you feel you need more information or clarification, please do feel free to contact us at info@dlhalaw.com, which is at the bottom of this screen, and we'll respond to you. With that, we have a lot today to cover, so let me introduce our panelists. First, you're going to hear from Lindsay Meyer. Lindsay is our senior employment attorney at DLHA Law. She leads our employment team in providing legal advice and representation to our business clients. This advice is given to ensure legal compliance regarding both federal and state employment-related matters. Today, Lindsay will be discussing employment law updates that will impact employers beginning this year. Next, you'll hear from Kellen Stevens. Kellen is our senior transactional attorney at DLHA Law. He formerly worked in banking and commercial lending and now leads our transactional team at the firm. His primary focus areas at the firm are corporate transactions and compliance, commercial agreements, estates, sales and acquisition, and succession planning for companies of all sizes. Today, Kellen will address the changing landscape of privacy laws in California, as well as provide updates on COVID-19 laws and regulations. With that, let me turn it over to Lindsay, and I will return at the conclusion of the webinar presentation to lead the question and answer session. Lindsay?
Thank you, Angela. Good afternoon, everyone, and thank you very much for joining us today. As Angela advised, I will start us off today by discussing updates in employment law that are in effect as of the beginning of this year, as of January 1, 2023. First and foremost, I'm going to be talking about several types of leave that have been expanded in California. The first is the leave provided under the California Family Rights Act. And secondly, I will talk about paid sick leave, as they have a somewhat similar addition. So as of January 1 of this year, regarding who an employee can take leave for, to care for under the California Family Rights Act, CFRA, and California's paid sick leave law has been expanded. And now there's an additional category of person to take leave for, defined as a designated person. So what does that mean? Specific to CFRA, prior to the update, CFRA leave permitted leave to care for a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. So quite a few categories already. But as of the beginning of this year, 2023, it also includes taking leave to care for a designated person. And the definition of designated person applicable to CFRA leave means any individual related by blood or whose association with the employee is equivalent of a family relationship. And CFRA leave, or an employer rather, that is covered by CFRA leave is an employer that has 5 or more employees. Now, there's a slightly definition for designated person regarding California's paid sick leave that employees are entitled to. And California paid sick leave is applicable to employers of all sizes. And the definition does slightly differ, and it is defined for purposes of taking sick leave in California as a person identified by the employee at the time the employee requests the paid sick days. So unlike CFRA's definition of a designated person, this definition does not state that the individual need to be related by blood to the employee or that their association need to be the equivalent of a family relationship. Subject to guidance that's provided by California's Labor Commissioner, a designated person for the use of paid sick leave purposes possibly might include a roommate, a new romantic partner, or even a next door neighbor. So again, it's more expansive and broad, the definition of designated person when applying it to whom an employee can take sick leave off to care for, versus CFRA is still slightly more narrowed to an individual whose association is either it's family in nature, either related by blood or equivalent of a family relationship. However, both the amended CFRA and paid sick leave laws as of this year permit employers to limit an employee to use one designated person per 12-month period. So that's a little different than how it's permitted to be used for family members, for example. So under CFRA leave, employees who are eligible, they can use up to 12 weeks of protected leave in a 12-month period. If they use 6 weeks, for example, for a designated person, and then in that same 12-month period, they wanted to use their remaining 6 weeks for a second designated person, the employer could legally, under this update in the CFRA law, say deny the employee to use that leave because they've already used, they've already designated selected one designated person within that 12-month period. Now, if an employee used 6 weeks of leave for a designated person, and then that same 12-month period, they wanted to use the remaining 6 weeks to care for their mother, for example, that would be permissible and the employee would be entitled to use the leave accordingly. So it can get a little tricky. So when permitting an employee to use leave, or probably even more importantly, if you're thinking of denying an employee to use leave for a designated person, check with your legal counsel to make sure you're appropriately doing so. The other type of leave in California that has been expanded is the bereavement leave. Previously, this was not considered a protected leave of absence, but it is now, as of 2023, considered a protected leave of absence. And the law does apply to private employers with 5 or more employees and all public employers. Employees may take up to 5 days of bereavement leave now upon the death of a family member, which includes a spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. And this actually applies per occurrence, not just 5 days per year. You'll note that there is not that additional category of designated person, or at least not yet, under bereavement leave. The bereavement leave can still be unpaid. However, employees are entitled to use any existing available paid leave they have on the books, such as vacation, PTO, or sick leave. And the employer can require documentation from the employee to support their need for the leave. And the leave must be completed within 3 months of the family member's passing. Next slide, please. Additionally, California's Fair Employment and Housing Act has also been expanded as of the beginning of 2023. I will cover 2 of the recent expansions. First, cannabis protection has been added to the state's discrimination law. However, it does not go into effect until the 1st of next year, but it is going to be a pretty big change. So I thought it was important to mention in this webinar. Specifically, employers as of January 1, 2024 will be prohibited from discriminating against an employee or job applicant based on the person's use of cannabis off the job and away from the workplace. Employers may absolutely still conduct pre-employment drug testing and refuse to hire someone based on a valid pre-employment drug screening that doesn't screen for non-psychoactive cannabis metabolites. An example of a non-psychoactive drug would be one that does not produce an effect on the mind or mental process or cause a change in perception or behavior. The law also does not permit an employee to possess, be impaired by, or use cannabis on the job, or affect the rights or obligations of the employer to maintain a drug and alcohol-free workplace. The second update, or expansion rather, to the Fair Employment and Housing Act is effective as of the beginning of this year, 2023, and FEHA has been amended to make it unlawful to discriminate against an employee or job applicant based on their reproductive health decision making. So this is now yet another new protected class, protected category that has been added. Reproductive health decision making includes, but is not limited to, a decision to use or access a particular drug, device, product, or medical service for reproductive health. And there is actually an updated poster that is available that you can access if you go to the California Civil Rights Department, previously known as the Fair Employment and Housing Department, that is required for employers to now be posting or providing to their employees. And it specifically now does include the category of reproductive health decision making. And with that, that concludes my coverage of the expansion of CFRA, and the CFRA and the California Fair Employment and Housing Act, and I will return the floor to my colleague, Kellen Stevens. Thank you.
All right. Thank you so much, Lindsay. I appreciate it. So what I'm going to be starting to talk about today is the privacy rights in California. You might already be familiar with some previous legislation in California. It was called the California Consumer Privacy Act. And that was in existence, and then that became in existence in 2018, but the operative provisions weren't effective until 2020, and it had replaced another piece of legislation. They kind of operated with each other together. The point of both of them, generally, and with most privacy regulations around the world, was to protect the consumer data. As different companies were using more and more consumer data, there weren't a lot of rules around it. So government started to establish specific rules and regulations on what could be collected, how it was disclosed, and how it was handled. California was one of just a few states in the United States to come out with the California Privacy Rights Act in 2020, which was a big step in protecting consumer data. Now, what's happened currently is that the California Privacy Rights Act effectively has supplanted the previous privacy regulation. And there have been some changes in what is required of business owners. And so what I really want to talk about today is the shift from focusing on consumer privacy to employee privacy and what that means for business owners and their employees. So the first thing to know is that I assume every business that we're discussing is operating business within California, and it has to be for these regulations to apply. And these regulations started, the operative parts related to employees started on January 1st of 2023. So we're first looking at a covered business. Now, this has been defined as 3 different types of businesses. And any one of these, if you meet the criteria, you are a covered business. So if you have $25 million in gross revenue for the prior year, if you buy, share, or receive personal information of more than 100,000 consumers or households, and that's alone or in combination. So if you have 4 people in one household, that's 5 total. Or 50% of your revenue is acquired from selling consumer personal information. So those are the 3 broad categories. And the biggest change that we're seeing now is the $25 million in gross revenue. If you fall within that category, then you have 1 year to start complying with the new rules. And the effect on employees is basically treating them very similar to how consumers were treated under the previous privacy regulation. It expands employer obligations from those consumers to also handling workforce employee data and the business to business data that you exchange that's regarding personal information. So what it means effectively is that covered employers will be required to provide employees with privacy notices. They're going to have to respond to data rights requests. They have to limit use and disclosures pursuant to the new rules, and they have to obtain specific contractual commitments from third parties that receive their personal information. And I was mentioning data request and use and disclosures. So what employees can now do is they can request that companies disclose information that's collected about them, and the companies have to be able to respond to that request. Now, the employees have different rights associated with different types of data. They can request that certain data be deleted. They can request that data be corrected. They can request that or direct the company to not sell or share the personal information, which happens, I think, more frequently than people realize. And they can generally limit the use of certain sensitive personal information. Just briefly, personal information, there's two types of, there's a distinction between personal and sensitive personal information. So personal information is that which identifies a particular person or a household in any way. And then sensitive personal information is something like a social security, driver's license, race, ethnicity, religious affiliation, union membership. The new California privacy laws created these two types of data subsets. And for sensitive personal information, you can imagine that there are more strict rules around how that's handled and the employees' control over that information. So employers now have to provide employees notices of their rights under the CPRA. But remember, this is only if you're an employer that meets one of the three thresholds. So if you 50% of your revenue or 25 million or 100,000 households. And they have to give employees a way to tell them about exercising their rights. So if you tell them that the new laws are in effect, then how can they go about controlling their data? Typically, we'll see that these notices to employees are going to be drafted by counsel for your companies that understand the privacy law. And when employees submit requests about that information, you also want to be sure to log those and make sure that you're responding accurately and in a way that protects the company. A good thing to have also is policies and compliance procedures, which are, again, typically drafted and reviewed by counsel. One thing that employers are using to kind of just get a general understanding of the different types of data here is they create data maps. They break down things between personal and sensitive personal information, and they determine how do we collect it? How do we obtain it? How do we use it? Who do we share it with? This is a type of nuanced introspection of consumer and now employee data that more and more companies are going to be subject to in order to protect employees and, of course, consumers from their data being inappropriately used or sold. The California Privacy Protection Agency is the new agency that has been established to update and issue regulations regarding notices. So I would say that it's really important to be aware that that is a real agency, the California Privacy Protection Agency. You know, if you receive notices from them, whether email or mail, be aware that that might be related to new regulations that you should be aware of, or some other reason that they're contacting you, but it is a valid state agency that is attempting to contact you as a business. And so I think that it's just important to keep that in mind as you go about assessing your role in managing your employee data. So I know that's a lot. The whole privacy law industry is burgeoning. First came the GDPR in Europe. Like I said, different states have passed legislation. There has been different federal legislation. California's is quite comprehensive, and it's going to continue to grow. And so I think that if you're think that you might be a business that is covered and that you have to possibly start figuring out how you're handling different employee or consumer data, that you want to talk with a specialist and figure out if that is in fact true, if you meet the thresholds, and then come up with a strategy that you can implement as a business that's sensible and compliant with the laws. Okay, so now I'm just going to move on to COVID-19 related laws. There we are through, hopefully through most of the variants and the worst of the pandemic, and life is returning to normal. There have been still continuing updates to laws that are related to COVID-19, and a few of these we just want to make sure that businesses are aware of. So the first is, I know that this is now January 11th, but California had COVID-19 supplemental paid leave. That was set to expire in September 30th of 2022. It was extended to December 31st. The important thing to know, I think, as an employer currently is that if an employee was already on this leave prior to the end of the year, they can continue to take this leave until their bank of leave is used up. So it's a good idea to, if you don't already, to track this. But if employees have not used it up until this point, then it is no longer available for them. The next law that I want to talk about is AB 2693. This was a law that was related to notifying employees about exposures at the workplace. And it said that employers, instead of providing written notice to the employees, could now post notice in the workplace, about the exposure, the date, the location, the people, the benefits of the sick leave, disinfection plans, and the like. So a lot of the things that would be included in an individual written notice. This seems to be, one way that we are kind of adapting to the new normal of COVID, just maybe being a less serious but persistent threat within the workplace and society. However, the important thing that I want to point out is that if you've heard that this is all that's required, OSHA, under the emergency temporary standards that were established, they still require a written notice to employees. And so as an employer, if you're just posting it, you still have to provide written notice to the employees. So until either the OSHA emergency temporary standards are removed, not removed, but changed or modified to be more consistent with the new AB 2693, you should basically still always provide written notice about workplace exposures to the individual employees. Okay, and then lastly, I just need to touch on workers' comp, AB 1751. So this is a law that has been extended through 1/1/24, and it essentially creates a rebuttable presumption that if someone has an injury or death from COVID-19, that the law assumes that they contracted COVID-19 from the workplace and that they are entitled to workers' compensation benefits. Now, this is a rebuttable presumption, so an employer can appeal it and demonstrate that there was not like a positive testing. There's also a lot of nuances with this law that I didn't really want to get into just considering the time that we have. But I think that it's just important for any business owner to understand that if an employee is claiming workers' comp based upon a COVID-19 illness, injury, or death, that can be valid in certain circumstances for certain employers. And I know it's nuanced like that, but that's the way it's written. And so if you're going to, depending on how you want to handle that claim, you should consult with a legal counsel so that you can get an accurate opinion about whether it's covered or not. Okay, so that's what I wanted to provide with COVID-19 laws. And now I'll turn it back over to Lindsay. Thank you all very much.
Thank you, Kellen. That segues nicely into my next topic, workplace safety. There are, as expected, several updates to the California Labor Code that impact the workplace the employer should be aware of as of 2023. First, Labor Code Section 1193 is added, and it prohibits an employer from taking or threatening adverse action against any employee for refusing to report to work or leaving the workplace or work site early because the employee had a reasonable belief that the workplace was unsafe in the event of an emergency condition. So that's a lot there to take in, but really what's important to focus on is it's in the event of an emergency condition, and there's a specific definition of emergency condition, of course. And what that is under the update to the labor code is an emergency condition is considered the existence of either conditions of disaster or extreme peril to the safety of persons or property at the workplace or work site caused by natural forces or criminal act, or in order to evacuate a workplace or work site or a worker's home or the school of a worker's child due to a natural disaster or criminal act. So essentially, an employer cannot, again, take any adverse action against an employee if there was an emergency condition and that employee had a reasonable belief that they were in danger. Now, emergency condition specifically excludes a health pandemic. So again, if an employee is saying they don't want to come to work because of COVID-19 or something, for example, they're afraid they're going to contract COVID-19, that is not something that's included in the definition of, at this point, emergency condition. So that would be an issue that an employer could actually, ultimately, depending on the circumstances, possibly take some action with the employee, maybe write them up or something if they're refusing to come into work. But again, before taking any disciplinary action, it's always important to reach out to your legal counsel and make sure you're handling it properly to avoid any unwanted, definitely unneeded claims. There's enough going on without addition of any claims to be dealing with. The statute obviously does not apply to certain specified workers, and those include, but are not limited to, first responders and employees who provide direct patient care at a healthcare facility. Also, this updated labor code section prohibits employers from preventing employees from accessing any of their mobile devices, communication devices to seek emergency assistance, assess the safety of a situation, or communicate with other people to verify their safety. Next slide, please. There are several changes actually that impact pay in California relating to the employer-employee relationship in 2023. California has recently passed a law in an effort to bolster pay transparency and counter workplace discrimination. This transparency regarding pay is now aligning California with several other states that have already taken this action, including New York, Nevada, and Washington. As of the beginning of January 2023, California law has expanded the annual pay data reporting requirements on employers and also is requiring covered employers to disclose pay scales to employees and their job applicants. First, I will cover the annual pay data reporting, and then I'll move on to discussing the pay transparency. So regarding the annual pay data reporting requirement on employers, prior to this recent update in the law, employers with 100 or more employees and that were required under federal law to file an annual federal employer information report known as the EEO-1. They included in that count of 100 employees was not employees that they obtained through a labor contractor or a staffing agency. However, now the law does address those workers that are supplied to employers via a labor contractor, again, also known as a staffing agency. So as of the beginning of this year, covered employers who are supplied workers by a labor contractor, staffing agencies will not escape this pay data reporting obligation. The law defines labor contractors as an individual or entity that supplies either with or without a contract a client employer with workers to perform labor within the employer's usual course of business. So for example, if an employer has 50 in-house employees and then has 50 additional employees that are provided to them through a staffing agency, that employer would be considered a covered employer having 100 or more employees and would have to fulfill the annual pay data report requirement. The pay data report must be submitted to the California Civil Rights Department, which as of last year was known still as the California Fair Employment and Housing Department. So the name has changed. The act still remains the same, the Fair Employment and Housing Act, but the department name has changed to the California Civil Rights Department. In addition to reporting the number of employees by race, ethnicity, and sex by job title categories and pay bands, California employers must also report the median and mean hourly rate within each job category for each combination of race, ethnicity, and sex in the report. So it's quite a lot to cover. Generally, your payroll companies can work with you to get this report together, but you should have, especially with this recent change, have your legal counsel review it to make sure it's compliant. Employers with multiple establishments are required to submit separate reports for each establishment instead of a consolidated report, and are no longer permitted to submit this information via the Employer Information Report, the EEO-1, in lieu of the required pay data report. An employer who fails to submit the required report to the California Civil Rights Department may be subject to costs associated with compelling compliance. A court could also impose civil penalties up to $100 per employee and up to $200 per employee for subsequent failures to file the pay data report. The previous deadline as of last year was March 31st. However, while the California Civil Rights Department website has not been updated, under the update, which should be changed pretty soon, I'm expecting, we did reach out to the California Civil Rights Department prior to our webinar, and they confirmed the website just has not been updated yet. But the deadline actually is a little bit later. It's going to be the second Wednesday now in May. So in 2023, that would be May 10th of 2023. But again, the previous deadline was March 31st. So you have a little bit more time, but I would check with the California Civil Rights Department just to verify that is the correct date, since it appears to be that's what it should be, but they just have not updated their website yet. Now, as pay scale disclosure, this is quite different. This is brand new for California. As of the first of this year, covered employers, which include employers with 15 or more employees, must include the pay scale in all job postings under California Labor Code. And the pay scale under the particular section of the Labor Code is defined as the salary or hourly wage that the employer reasonably expects to pay for the position. So there can be a range, but it has to be what the employer is reasonably expecting they will pay for the position. Also, if the covered employer, one who has 15 or more employees, announces or publishes job postings using a third party, the employer must still provide that pay scale information to the third party to include in the job posting for them. Lastly, upon a request, a covered employer must provide the pay scale information to any of the employer's current employees or to any of their job applicants. It's important to comply with this because, not surprisingly, a failure to comply with the required disclosures will allow an aggrieved employee or applicant to file a written complaint with against the employer with the California Labor Commissioner within 1 year after learning the employer did not make the required disclosure. If the Labor Commissioner were to find the employer did in fact violate the Labor Code regarding this matter, the Labor Commissioner may order the employer to pay civil penalties, which could range anywhere from $100 to $10,000 per violation based on the totality of the circumstances. So again, very important to comply with this new Transparency Act in California. And lastly, as of 2023, the California minimum wage, as usual in each new year, has now increased, but it's slightly different this year because in previous years, there were two categories of minimum wage, one for small employers who had 25 or fewer employers, and one for larger employers who had 26 or more employees. Now the categories as far as small and large employer have been done away with for this year at least, and straight across the board, all employers in California must pay a minimum wage to their employees of at least $15.15 per hour. It is very important to note that many cities and local governments in California, however, have enacted minimum wage ordinances that do exceed this new state minimum wage of $15.50 per hour. And that does include cities such as Alameda, Berkeley, Los Angeles, as well as West Hollywood, Palo Alto, Richmond, San Francisco, and many more. So if you do have employees who regularly work in San Francisco, for example, or regularly work in Berkeley, and at other times work in a different location, you want to make sure you're tracking where they're working and what the minimum wage is for that particular city they are in. Next slide, please. This is very important, and I want everyone to make sure that they take a look at their websites after the webinar today. We have had a lot of clients coming to us receiving demands in the last several years from plaintiffs regarding their business websites being out of ADA compliance. Now, many business owners have been for years aware of ADA claims where there's plaintiffs who will go, for example, and hit every business down a block and bring a claim for them failing to have an access ramp or enough accessible parking, for example. But now, in the recent past few years, there's been quite a movement with plaintiffs who are visually impaired, bringing claims against businesses for their websites being out of ADA compliance. And that means that they're not accessible to an individual with no to low vision, where they use particular software for the screen, for example, to read to them. And if your website doesn't comply with that, then they won't be able to access your website just as anyone else could who was not visually impaired. There is some movement with the California courts where they are starting to take some steps to protect businesses from the onslaught of these ADA claims against their websites being out of compliance. Just this past August of 2022, the California Court of Appeal did join the Ninth Circuit precedent in determining that businesses that are online only are not public accommodations covered under the ADA. In the particular case I'm discussing at the moment, the blind plaintiff brought an ADA claim against a company that was an online business only. It was an online cleaning supply company. And ultimately, the court held that this company was not a place of public accommodation under the ADA because it had no physical presence. It was an online company only. It had no store, for example, for an individual to go and access. So at least there is some movement towards protecting businesses from these types of lawsuits. However, this is a very viable claim that individual plaintiffs can bring if a website is out of ADA compliance, and it is a civil rights violation and subject to a minimum statutory penalty of $4,000 per violation plus attorney's fees. So it can get quite expensive quickly. So it is very important to consult with your legal counsel if you aren't unsure if your website is ADA compliant, and also reach out to your IT department as well. But even if you do reach out to your IT department, you will want to consult with your legal counsel just to ensure that all the categories of compliance are being met. And with that, I will turn the floor back to Ms. Angela De La Housaye. Thank you.
Thank you so much, Lindsay and Kellen. We hope this has been informative. We have a few questions, so we'll entertain those and give answers. If you feel that you need more information, as I said, please don't hesitate to contact us, info@DLHALaw.com. Let me take the first question because I know this is everyone's lunchtime and I want to be sure everybody gets the benefit of hearing the answers in full. The first question is, does an employee receive new bereavement leave if another member of their family passes away in the same year. So I'm going to let Lindsay answer that.
Okay, thank you, Angela. I believe what the question is asking is if, for example, an employee has two family members pass away at different times, but in the same 12-month period, does the employer have to permit them to take this protected bereavement leave each time? The answer is yes. Bereavement leave is per occurrence. So if an employee's mother passed away, for example, this year in February, and then had a sibling pass away in July, that employee would be permitted in each instance to take up to 5 days of unpaid leave to go and handle the situation, go to the family's funeral, etc. It is per occurrence, and also the employee, if they did have any paid leave on the books, would be entitled to use that as well if they wanted to.
We are getting a lot of questions about this from our business clients. And we always recommend, taking a look at your handbook every year, making sure it's modified every year to reflect the new changes in the law. And then also your counsel goes through your handbook to make sure that the different sections are consistent. I will emphasize that companies with handbooks fare very better in the event of a challenge than companies that don't have one, because obviously it's in writing, you can turn to it, and the employees sign it, so they agree to the terms. The second question is, are the privacy rules going to start including smaller businesses in the future? So, Kellen, do you want to take that one?
Yeah, sure. So I think that there's certainly like a public policy benefit to the privacy rules, right? California is the only state that's expanded them. And this is what the change has been for 2023, is expanding the consumer protections to employee data, because in every other state and prior to 2023, employee data was exempt. However, with that idea of like the interest of protecting not just consumer, but also employee data, there's the logistical burden that it places on businesses. And if that burden is too high, then you just will not have compliance from businesses, right? So they have to make sure that they are setting it at the level that the businesses that are most responsible, that are most impacted, can handle it. And that's why you will see it's people that work specifically in privacy data, right? They already kind of have those systems working, or that $25 million in revenue. And so it's probably not likely that they're going to keep pushing the thresholds down, whether it's gross revenue or it's some other or the other methods of collecting data, because there just comes a point where businesses just won't comply because they don't have the capacity, the bandwidth, the expertise, or the money to do that. And so there's that trade-off. So I don't really think so now. I mean, we always pay attention to these changes in the laws. We've seen this change now, but this has been a long time coming. So right now, I wouldn't think so, but I would make sure that if you're approaching those thresholds, whether it's the data or the revenue, that you kind of do an assessment early on and you make a plan early on so that you're not stuck with any non-compliance in the future.
Okay, great. Thank you.
Sure.
Second question, or the third question, has to do with privacy rights as well. How do I stay up to date on the California privacy right rules for my business? Kellen, do you want to take that one?
Sure. Well, that's what we're here for. But I think the rules are they're complicated. They've been written. It's a whole new arena. It's a whole new ecosystem, and the idea of trying to protect people sometimes requires a lot from businesses, and there's sometimes as much planning as there are unintended consequences. And so staying up to date on them is just, you will see things reported in the news about changes to privacy laws. You might see a business that inappropriately handled employee data. And if you see those things, it's a good time to say, am I possibly being exposed here? Is this something that I should do? And then you can reach out to counsel to figure that out. But other than that, like I said, it's just a very convoluted lot of extensive laws, and that California Privacy Protection Agency is going to continue to provide additional regulations. So that's one place that you can look if you're already past the threshold to, find help with like providing notices and responding to requests. So that's one place to look, and then also work with your counsel.
Okay, wonderful. Thank you. So the last question we have is a twofold question. The first part of the question, I'm going to respond in the question and answer box because we need a little bit more information and we need to talk to the attendee directly about the question to refine it and refine the answer. But the second part of the question, I'm going to have Lindsay answer if she could, and that is when we have to post pay scales of all employees, do we have to put their names on the pay scale listing, or is it just by job category? I assume this is under the new law.
Hi, yes, that would be, no, you wouldn't be including the employee's name. You would just be including, it would be for the job category. You would list for the job category being requested. And you could say a reasonable range. So you don't have to say exactly, but it should be something reasonably expected to be paid to regarding that particular position.
Okay, great. Thank you. Well, I said it would be about 45 minutes. We're at the 45-minute mark. We really enjoy doing these updates and we enjoy working with clients. We encourage you to reach out to us if you have any questions. And thank you so much for taking the time out of your day to join us. We give several webinars a year on varying topics, and you'll see the outreach on those from Heather Larson at our office. Please feel free to sign up if you're interested in any of the other webinars that we provide during the year. Thank you again for attending. Stay dry out there, stay safe, and have a wonderful rest of the week.